bienvenido a mi canal. Yo me llamo Sirey. Soy una abogada afro-latina licenciada practicando las leyes criminales, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a continuar de hablar de Ri'Shard Ferguson. Si quieren más video en español, nada más dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latina criminal attorney who, much like the rest of you, has a severe fascination with true crime cases. Listen, you guys, have I ever told you about how corny I think my intro is? It's ridiculously corny. It's like corn on the cob corny. It's like cornball corny. But I do it because I think I'm a little corny in real life. If you guys ever got the opportunity to meet me, you'd be like, yeah, okay. Second, since we last talked about the case of Ri'Shard and Ri'Shard Ferguson, Ri'Shard has been sentenced. The sentencing hearing was public, it was recorded, it was made available for all of us to consume. So without anything further, let's go ahead and get started. This is the case of Ri'Shard Ferguson. Wait, before we get into it, can you guys see my cute little table back there? Yeah, I'm starting to add more things around me, surrounding me, what have you, so you guys can just see an ambiance and catch a vibe. But anyways, let's go ahead and get started. If you guys have not watched that last video, let me just go ahead and give you a little brief recap. Ri'Shard Ferguson is a 68-year-old Floridian father, or was 68 at the time. And Ri'Shard Ferguson was charged and convicted of 4 separate counts of manslaughter after he granted his 15-year-old son, Ri'Shard Ferguson, permission to use his vehicle, knowing that Ri'Shard was unlicensed. And ultimately, Ri'Shard, driving unlicensed, caused a collision that killed 4 individuals. At the time we originally discussed this case, I expressed my trepidation, I guess is the best way to say that, with the fact that Florida charged Ri'Shard for the murders that Ri'Shard committed. But once again, if you have not seen that past video, I will just say that Florida, Texas, a lot of the down south states are really strict and they have harsher penalties and harsher sentencing than some of the others, in my opinion. So although it was a surprise to me that he was charged, when I discovered he was in Florida, the surprise completely went away. In the last video, we discussed the jury trial and how Ri'Shard's 3 underage friends came onto the stand and testified that they believed that Ri'Shard had granted Ri'Shard permission to use the vehicle. Please keep in mind that Ri'Shard had a different story. He stated that he did not give his son permission to use the vehicle, but instead just asked his son to move the car out of the driveway or somewhere. Just brief movement was the story that he told. In the prosecution's rebuttal close, the prosecution covered all the questions that I, or most curious minds, would want to know. If it is true that your son took the vehicle without your permission, what subsequent steps did you take in order to report that vehicle stolen? And there were no good answers. So ultimately, following the conclusion of all evidence and at the end of the trial, the jurors convicted Ri'Shard of all 4 counts of manslaughter. Before we discuss what happened at the sentencing, let's talk a little bit more just to refresh your memory on what happened with Ri'Shard Ferguson. So if you'll remember, Ri'Shard was 15 years old at the time that this happened in September of 2023. By plea agreement with the prosecution, Ri'Shard pled guilty to manslaughter, again, how many counts of which I am not sure. However, by virtue of that plea, there was an agreement amongst the parties that Ri'Shard would spend up until his 19th birthday in juvenile detention, and following that, he would be placed on an additional 2 years of supervision. Aside from my initial reactions regarding the charging decisions here, another thing that came to my mind was, what plea, if any, did the prosecution offer Ri'Shard in this case? And let me tell you this, typically during sentencing arguments, it's not really common for the prosecution to comment on past plea negotiations. And the reason for that is because they're irrelevant. I'm not saying it's wrong. I don't think there's any rule that prohibits them from doing so, to the best of my recall, in the states that I'm licensed to practice in, but it's just not really common. All that to say, the prosecutor here actually commented on the past plea agreements that were offered to Ri'Shard, and my mind was blown.
Your Honor, Mr. Ferguson's actions in this case result in the death of Trinidad Hernandez, Miley Cruz, Marvin Cruz, and Anayari Hernandez. Prior to trial, the state did make two plea offers to Mr. Ferguson. One was for a 5-year DOC sentence. The other one was for a open plea to the court with a 10-year cap. He chose to go to trial, and at trial, he denied any responsibility for his actions.
Okay, if I remember correctly, the name of the prosecutor in this case is Brian C. Hagner. So what Brian C. Hagner stated was the first offer that was given to Ri'Shard was a stip to 5 years of DOC. Because I love you guys, I live for you guys. Hopefully you are living for me in all of these videos that I'm trying to explain to you guys. Let me explain what that means. Stip 5 merely means this. By agreement of the parties, Ri'Shard would enter into a plea agreement by which he would plead guilty to at least 1 count of manslaughter, or whatever it is that the prosecution wanted him to plead guilty to. And they would agree that he would serve 5 years in prison. DOC is Department of Corrections, so he would serve 5 years in prison. Let's stop. Let's break that down because I want us to think about it. If this happened in 2023, and let's assume that Ri'Shard was also arrested when this happened in 2023, and let's assume Ri'Shard has been in custody the entire time from 2023 up until now, that's already 3 years. If Ri'Shard would have agreed to that plea, regardless of when it was offered, he basically would have like another 1 or 2 years. And I say basically because neither the prosecution or the court calculate good time or earned time. The prison does. So he would have gotten credit for the time he has already served. So let's assume that's already 3 years. And then he would be stuck with the remainder of the 2, minus whatever good time is calculated from the prison. So all that to say, he could have, for all intents and purposes, been out right now. The next plea agreement that the prosecution offered Ri'Shard was an open cap 10. And let me explain what that means. An open plea means that you're pleading to whatever charge that the parties agreed for you to plead to. So to simplify this, let's call it manslaughter. Let's say he pled guilty to manslaughter. The sentence is open to the court's determination, but whatever sentence the court imposes cannot exceed the cap of 10 years. Does that make sense? Now, why is that beneficial to Ri'Shard? Well, second-degree felonies in Florida, what we learned last time, have a maximum possible penalty of up to 15 years. If the prosecutor caps that at 10, that limits Ri'Shard's exposure by 5 years. Do you get it? So yes, you can plead open to the court, and yes, the prosecution can ask for 10 years, but ultimately it's up to the court's determination. Now, how is that beneficial to Ri'Shard or more beneficial to Ri'Shard than the stip 5? Because if it is not a mandatory prison charge, then Ri'Shard would have the opportunity to ask for a lesser sentence, including probation, if it's allowable, if applicable, and if the court determines it's appropriate. Does that make sense? So basically, what the prosecutor is saying here is, Ri'Shard, I will give you an opportunity to ask the court for probation if applicable, but if not, for a lesser sentence than the 5 years that I'm trying to have you stipulate to. But I'm not going to agree to it. You can ask for it. It's well within your realm of possibility, but I'm not going to agree to it. Now let's break it down even further, you guys. Let's assume Ri'Shard accepted the open cap 10 and the court in its discretion decided to impose the maximum possible penalty of 10 years. Assuming again that he was in custody from 2023 up until now, he still would have been closer to release if he accepted that plea agreement. All this to say, Let me show you what the court ultimately sentenced Ri'Shard to.
You are sentenced to 444 months, 444 months and 0.15 months in the Department of Corrections. That equates to just over 37 years. Those sentences will run concurrently for each count.
So there you guys have it, and you saw it for yourselves. The court in this case sentenced Ri'Shard to 37 years in prison. That just has to hurt. First, I will let you know my opinions on it. I will let you know my thoughts about how all of this went down, and then I'm going to ask for you guys to let me know what you think. If you guys did not already know this or you weren't aware, in most, if not every single state ever, I just say most because I'm not licensed to practice in all states, so I'm going to generalize. In most states, if not all states, there is something called a VRA or some variation thereof. A VRA stands for a Victims' Rights Act, meaning anytime a prosecutor decides to extend a plea agreement in a case that involves a victim or victims, they are required to attempt to get the victim or victim's family members, in this case, because the remaining victims are gone, they are required to get input from the victim or their family members. All that to say, I cannot imagine a conversation that the prosecution would have in this case with the surviving family members of the victims, telling them that the person that killed your family members, so Ri'Shard, is getting an agreed upon 4 years, and we're going to offer his father an agreed upon 5. I don't know anyone who would be okay with that, but the prosecutor did. I'm saying that with almost 100% confidence. They have to talk to the victim's family members, period. Now, let me tell you this. It doesn't mean that they have to agree with the victim's family members. So if the prosecutor thought that that was an appropriate plea, ran it past the victim's family members, and the victim's family members disagreed, they can voice their disagreement with the court, but the prosecutor can still ultimately extend it, right? But regardless, the conversation had to have been a difficult one. And then to go back to the same family members and say, listen, the father rejected the stip 5. We're going to offer him open cap 10, and explain to them that that gives him the possibility to serve something less than 5, and have them agree or express whatever concerns they have about it. Again, that could not have been an easy conversation. So the prosecution, in my opinion, gave Ri'Shard not 1, but 2 separate chances at a renewed life, meaning you could have been out. And he rejected both, only to be serving and sentenced to 37 years in prison. This case is really tough for me. It's tough in all regards for multiple different reasons. First, I think it was cruel to charge Ri'Shard for giving his son permission to use the vehicle. So I'll start there. Of course, there needs to be accountability for the fact that 4 separate people are dead because of Ri'Shard's actions. But in my mind, the accountability should have lied solely with Ri'Shard. We can disagree on that point, but that's how I feel. Now, second, it kind of feels like a slap in the face. Like Ri'Shard slapped the prosecution in the face, Ri'Shard slapped the judicial system in the face, and Ri'Shard slapped these victims and their family members in the face by not accepting accountability for anything, already knowing that you were charged. You were already charged. This is Florida. There are no games here. There's no magical theater. You were already charged. Why would you not accept accountability knowing that you were already charged? And maybe there's some of you that are going to say in the comment section, well, Desiree, why would he accept accountability if you think he shouldn't have been charged? Because you were. That's the simple answer, because you were, right? I have said numerous times in both of these videos, I think if it were a different state who was not so harsh, I don't know if the father would have gotten charged for merely giving the son permission. But You were already charged. Florida charged you. You're in Florida. Why would you not accept accountability for your portion or your part that caused the deaths of these people? And you guys, I'm not sure I already mentioned this in this video, but during sentencing, both Richard's attorney, Ri'Shard himself, and some of his family members testified that Ri'Shard is now suffering with stage 4 terminal pancreatic cancer. All bad. All of this is all bad. There's another case that I'm doing research on because I want to share it with you guys relatively soon. But basically, that case is a case where a father in Georgia was charged after his son shot up a high school in Georgia. And based on the facts that I know them to be so far, I think that was an appropriate charging decision. We're going to compare and contrast that case to this one because there's so many differences there that I want you guys to be able to see my thought process or what I go through when I'm thinking about whether or not the charges seem adequate and appropriate. And again, for the millionth time, I don't think the Floridian prosecutors did anything wrong by charging Ri'Shard. But that is it for this video, you guys. Please let me know anything it is you want to let me know down below. As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.